Hi everyone, Harry here to talk about E. Jean Carroll and some really volatile and incendiary evidence that the judge admitted for her trial, which is upcoming in less than a month, starting April 10th. All right, quick review. Remember, she says that Trump raped her in the mid-90s, just, barged into her dressing room in a department store and raped her. And when this allegation came out, it was too late, though there's a wrinkle, I'll tell you in a second, but it was initially too late to charge the rape or sue him for the assault. But he, in his chivalrous way, said, A, he never did it, B, she's not my type, he disparaged her looks, etc. And so she sued him for defamation. And so the trial is basically for defamation. Now, the asterisk is, just to remind everyone of the full bidding here, New York State passes a special law that gave a kind of a safe harbor for people who had been the victims of sexual assault going back, I think, like forever, to actually initiate the suit, notwithstanding what would have been a bar from the statute of limitations. So she promptly did that. So there's also now a second suit pending for the original assault. And Trump, genius that he is, re-upped on his defamation. Said the same thing again, never did it, not my type, etc. So therefore, there's no statute of limitations problem with the defamation. So it's the defamation that is scheduled to go to trial next month. Now, there are special rules of evidence involving civil and criminal cases. This one, though, is civil. And previous instances of sexual assault. So Congress has passed the federal rule of evidence is 415, and just to read it to you or let you know what it says, it is basically that in a civil case, based on a party's alleged sexual assault. Check. Although based on, right? It's interesting. It's defamation, but it's based on the assault. So the first thing that the judge in the Carroll case, who's been very strong for Carroll and very tough on Trump, says is it's based on evidence that the evidence doesn't have to be proven, beyond a reasonable doubt. Evidence that the defendant committed any other sexual assault may be admitted. So the judge determined that this is a case that's based on an alleged sexual assault. And then there's evidence that is out there about Trump. We know about a lot of it. And Trump came in and said in these pretrial motions, don't let her talk about that because it shouldn't count. And the first one is the Access Hollywood tape. So we all remember the final, line, grab him by the pee. Is that a sexual assault? I think probably doesn't cut it. It's just a sort of general comment about things that a star can do and the like, disgusting, but probably not a sexual assault. But I had forgotten. Remember the very beginning of the tape? He's talking to, I think it's Billy Bush, right? And he's saying, so the first thing we hear, she used to be great. She's still very beautiful. They're talking about a woman. And Trump says, I moved on her, actually. She was down in Palm Beach. I moved on her and I failed. I'll admit it. I did try and f her. She was married. Thank you, Donald Trump. So they can argue about it. He can try to say in the trial, oh, I was actually wooing her with chocolate and champagne, but, it doesn't sound like it. In any event, it's going to be admitted. And the whole tape, I believe, for the rule of completeness, as the lawyers tell. Maybe there'll be a skirmish, and don't have the final lines, etc. But I think that tape is coming in. Now, the reason this is a special area of law is one worries that a defendant, any defendant, even Donald Trump, will be the jury will be disgusted by and revile the defendant because of the other conduct. And even though you're not supposed to, of course, convict them for the other conduct or for being a disgusting person, it's supposed to be the evidence in front of the court. So that's why often past acts are kept out, but where they go to an important part of the actual case in front of the court, then there's an exception. You can bring them in. And here the idea is going to be, or this is the idea behind Congress's rule. They tend to show intent or absence of mistake. They tend to, it's not that he's a sexually assaulting kind of guy, but rather it shows that it was more likely that's what he intended to do with E. Jean Carroll. Of course, every trial lawyer knows, and every trial lawyer will tell you, it's a really volatile and worrisome rule for the defense, because what does the jury tend to conclude? He's a sexually assaulting kind of guy, and let's convict him. The same thing happens in other areas. The rules are more liberal in the sexual assault area, but if it's a bank robbery and you want to, prosecutors will say, bring in these other bank robberies to show intent. And, you'll have a big fight about it, and everybody understands once those previous bank robberies are brought in, that they're going to be very prejudicial in the eyes of the jury. Even though the judge will instruct the jury, you should take these not as evidence that he did it before, so he'll do it again, but rather about, intent and the like. If your head's spinning a little, it should be. It's a pretty thin distinction, but in real law terms, what something like this comes in and a jury goes, and it makes it more likely they'll convict. Now, we have two more, though, in addition. So, the evidence is just going to be killer on Trump. So there are two other assaults that are coming in. The judge ruled at the trial. One is Jessica Leeds. It's a name we've heard, but it's been a while. She says she's on a flight with, and of course they don't have to be within the statute of limitations. They don't have to have been a criminal conviction, just evidence of it. Trump, good luck to him, can argue, that didn't really happen. But Jessica Leeds can come forward and say, okay, I'm sitting next to him on a flight. They serve the meal, and then he's sitting next to me, tries to kiss me, grabs my breast, pulls me towards him, pulls himself on me. It's a physical struggle. It went on for a terribly long time. He starts putting his hand up my skirt. So this is a sexual assault, and she'll get up and testify, and it'll be killer stuff. And again, just make Trump look all the worse in the eyes of the jury. That's not the idea of it, but that's the effect of it. And everyone understands there's nothing improper about it. Though, let me say that you can imagine this becoming, Trump may have eventual claim on appeal to say it was too prejudicial. That's the thing that the judge had to decide, that it's sexual assault and it doesn't totally prejudice him in the eyes of the jury. But anyway, so even Ms. Leeds' account, if credited by the jury, reasonably could be regarded as describing unconsented to sexual contact. I mean, that's an understatement. If believed, it's a total sexual assault. And now we have Natasha Stoynoff. She was a writer for People magazine. She goes down to Mar-a-Lago to interview him and Melania. This guy is such an antisocial creep. He offers to show her up. So interviews him and Melania, and Trump says, would you like to see it? He offers to show her a painting there that was hanging in a certain room. He takes her there. She's looking around. She hears him close the door behind her. Then I turn around and he's right there, and he grabs my shoulders and pushes me against this wall and starts kissing me. Did he say anything before? Not that I recall. And what was going through your mind? Complete shock, complete shock. It was very fast. I was taken by surprise. I push him back. I'm flustered. He comes toward me again. And then someone came into the room. Sexual assault, plainly. And so the jury, the judges ruled, can hear this also under the rule I told you, evidence of prior sexual assaults. So this is going to, this evidence is gonna it's a bloodbath for Trump. It's gonna, he's going to look, like, well, because he is a complete monster, and particularly in this axis. So, it's going to really, I think, put Eugene Carroll on a downhill path to a very big verdict. And it's all coming up soon, guys. We pay attention mainly to the criminal stuff, but the civil stuff, especially this and the New York AG, which is a civil suit, are really big and important as well. Might not land them in jail. Won't land him in jail. Of course, it's not clear the criminal ones will either, but in terms of totally, killing his brand and killing his bank account, these are big and important cases. Particularly, it'll be something to watch if he testifies in this case, and if he doesn't, it's almost like it's something she can't lose. Again, remember, this is not beyond a reasonable doubt. Defamation, it's more likely than not, etc. Okay, so there you have it. Big stuff coming up. We're all focused on the 2 or 3 criminal cases, but this is April 10th. So that's soon. And there's going to be some just totally white hot evidence that will really replay his whole sort of history of being a repeat serial sexual assailant and the former president of the United States. All right, so stay tuned for all of this in the New York State Court on, actually, I should say in New York Federal Court on the 10th of April, a few short weeks from now, and this evidence in particular coming through, I believe, the actual memory of the victims. It's going to be really dramatic and, very, very tough stuff. And strong stuff for the plaintiff, Eugene Carroll, and her very aggressive and accomplished lawyer, Robbie Kaplan. All right, there you go. That'll be something to watch when it comes up. We'll definitely focus on it closely. And until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.